Hello, my name is Yong from group number 004. Today, me and my group members are going to be doing presentation. There are two parts in this presentation, part A, contract law, and part B, the law of torts and negligence questions. In both of the parts, it is going to be explaining about the issues, role, application, and conclusion. Part A, contract law issues. Whether the written memorandum constitute a binding contract between them, whether the parties to the contract intended to be bound by the written agreement, whether the performance of the contract will be suspended until the formal binding contract, whether Cameron will be able to retain the paid amount or Masters will get the refund. This case is related to a written memorandum signed for selling a firm to Masters by Cameron. The written memorandum stipulated the term that the agreement will be subjected to a formal sale agreement. Masters paid a handsome amount to Cameron's real estate agent for buying the firm on that same day. Later, Masters want to refund the paid amount, claiming that there was no binding contract between them and refused to complete the transaction for financial difficulties. It was important as if there was a binding contract, Cameron can retain the deposit money, otherwise he couldn't. Cameron claimed that the memorandum of selling the firm itself creates a binding contract between them, though no formal written contract was ever entered. Ultimately, they moved to the court for the solution. The rules that are going to be used to analyze the case of Masters versus Cameron are Wynn versus Bull, Rostio versus Miller, McCollum versus Hicks. Applications. Masters signed a written memorandum and paid euro 1,750. Masters refused to continue the performance of that stipulated for the financial crisis. Appellant's submission was no binding contract. Respondent's submission, a binding contract. The submission on behalf of the appellant was that there was no binding contract between them. The memorandum of the sale, while setting the general terms and conditions of the sale, was conditional only and subjected to another formal binding contract between them. There was no formal binding contract between them until the second document is signed and approved. Then the solicitor on behalf of the appellant claimed that paid money was earnest for good faith. The humble submission on behalf of the respondent was that the circumstances of the case stipulated and there was a binding contract between them, and she will not be entitled to refund the earnest money for the contract as she violates the material part of the contract. According to him, an agreement will be placed on the terms and conditions mentioned in the written memorandum. The effects of the above stipulation is that it limits the power of the parties to make subsequent terms and conditions for the contract, and in this way she is bound to that contract. The deposit paid by the appellant was the guarantee for the performance of the contract, and the appellant, being failed to perform his part of the contract, had no right to return.
Hi, my name is Elizabeth and I'm going to present Part A, Contract Law. In the first two scenarios, the parties of the contract intend a binding contract providing the stipulation that the contract will be immediately binding for the parties. In those cases, the contract will be immediately binding for the parties. On the other hand, in the third scenario, the parties of the contract do not intend for a binding contract. So in this case, the contract will not be binding for the parties immediately. In the present case, the stipulation of the subject to the contract intended the third scenario in most cases subject to contract clauses will mean parties intended the third scenario where the parties of the contract are not binding to each other until a formal document is executed. As the subject to contract clause of the memorandum does not intend the binding obligation until a formal document is executed, the court held that there was no binding contract between the Cameron and Master, and that's why Masters could recover the deposit from the Cameron. In this way, this case becomes an influential authority to determine the intention of the parties in the preliminary agreements. The intention of the parties is the sole basis of the determination of a binding contract according to this case.
Hello, my name is PAREKH, and today I'll be presenting the part B of the presentation, that is the law of torts and negligence. So today we'll be looking at the case of Hawkshaw versus Shaw 1984. In the present case, the defendant Shaw was the owner of a farm in Victoria. The farm stores petrol for farming machinery. The petrol of the firm was being stolen by trespasser, and Shaw made several complaints to the police. The police didn't succeed in capturing the thief, as there was no conclusive evidence in the hand of the police to capture the thief, and so Shaw decided to ambush the thief. He decided to lay near the tank to capture the thief. The plaintiff, Hawkshaw, was in the stolen car with Cox. So the Cox drove towards the farm and started stealing the petrol with the headlights turning off. For warning the thief, Shaw fired 2 warning shots with his pistol. The shot ultimately hit Hawkshaw, who was in the front seat. It was also clear from the case that Shaw didn't know Hawkshaw was in the car. Ultimately, Hawkshaw sued Shaw for compensation. So the issues in this case are whether there was a duty of care for the trespasser Hawkshaw, whether Shaw breached that duty of care by shooting with his rifle at the car, and whether Hawkshaw was partly liable for the injuries caused to her by trespassing on the land of Shaw. To further analyze the case of Hawkshaw vs. Shaw 1984, we are going to analyze some of the rules of the law cases, such as Commissioner of Railways vs. Anderson 1961, Adelaide Chemical and Fertilization Company Limited vs. Carley 1940, and Donoghue vs. Stevenson 1932. Moving on to the applications, the action of plaintiff placed him under the duty of care. Nextly, duty of care arose when he was the occupier of that farm, but from the fact that he discharged his firearms and created active present danger for the plaintiff. The court held that plaintiff will surely own the duty of care if the presence of plaintiff was known to the defendant. In the present case, the court did not doubt that the plaintiff had the duty of care, and the action of plaintiff placed him under the duty of care, which is similar to the case of Commissioner for Railways versus Anderson of 1961, and that the duty of care in this case did not arise from the fact that he was the occupier of the farm, but from the fact that he discharged his firearms and created active present danger for the plaintiff, and he should have foreseen that his firearm may cause harm to others like the above-mentioned case. The next question before the court was that whether the plaintiff owes duty of care from the defendant. The court in this case held the plaintiff will surely own the duty of care if the presence of the plaintiff was known to the defendant.
Hello everyone, my name is KUMBHANI and I'm gonna present my part of this presentation as one of my friend JEET discussed the law of torts and negligence questions issues, as we have picked the case study of Hawkshaw trespassing the farm of Shaw, and he discussed some of the issues related to this law. My part of applications, the most important aspect of law established in this case was likely to injure. If the requirement of likely to injure is fulfilled in any case, then the proximity of the case will be proved in that case. The proximity in this case is established in the case as the defendant discharged a lethal weapon at the plaintiff was in the line of fire. In the present case, the defendant was not forced to defend himself nor by surprise discharge the arm. He was there to abuse the petrol theft willfully. When a car drawn onto the property, it could happen that it might contain passengers as well as the driver. The obvious likelihood of presence of the passenger in the car suggests the proximity of the case. And that draws me to conclusion that this case law made it clear that an occurrence of the property can owe a duty to another person. Even the other person was a trespasser, if it is proved that trespasser could be injured by negligent act of occurrence and it was forcible. Thank you. It was all from my side. I hope you like our presentation. We work hard and research good about both of the laws and case study related to them. I would appreciate any questions regarding to our presentation. Thank you so much.